My name's Liz Losey, and I work as the Assistant Director in the Office of Educator Policy, Preparation, and Leadership, the Massachusetts Department of Education. I have the privilege and honor today of introducing our next speaker, who comes from the great Commonwealth of Massachusetts, Dr. Diana Pullin. Dr. Pullin is the Professor of Education Law and Policy at the Lynch School of Education and the School of Law at Boston College. The focus of her work is the impact of law on education practice and the impact of social science on the law. She is the former Dean of Education at Boston College. She has served as legal counsel for students, educators, and school systems in many different types of education disputes, particularly over high-stakes use of testing. She has published numerous books, chapters, and articles on education law and public policy, educational and employment testing, educator quality, and individuals with disabilities. Professional standards of practice have also been a focus of her work. She is one of the co-authors of the 1999 Standards on Educational and Psychological Testing. She has also served for a number of years as a member of the Joint Committee on Standards for Educational Evaluation. She is a fellow of the American Education Research Association and is a lifetime National Associate of the National Academy of Sciences. She serves on the board on testing and assessment of the National Research Council of the National Academy of Sciences and is the Associate Editor of the interdisciplinary journal Educational Policy. Please join me in welcoming Dr. Diana Pullin.
Good afternoon. There is a paper that accompanies my presentation. Before I begin, I'd like to thank the CCSSO and the SCALE project at Stanford University for the funding to support this research and writing. They were instrumental in not only providing the support, but also providing vital feedback in helping me as I worked my way through the project. One caveat before we dig in, this is not intended to address the full range of legal issues that would apply if you were thinking about on-the-job evaluation of practicing educators. This is focused more instead on the licensure consideration for individual educators and on program approval considerations for institutions preparing educators. I would say, though, that there are related issues in this presentation that would address some of the topics related to evaluation of practicing educators or to CAPE, perhaps, in terms of program accreditation. So let's focus on the legal issues, and let's think about it in as free and wide-ranging a way as we possibly can, which is how I've been trying to approach these latest phases of my work. So there is always this inclination to be concerned about legal issues and how to address them. And one approach is just to think about getting rid of all the lawyers. This is an approach, and you might be pleased to know that there are fewer and fewer people going to law school and fewer lawyers being hired, so there will be fewer of them, and no murder will be required. This is a response to the economic recession. Before digging into the legal issues, I think it's really important to consider the fact that no legal dispute, either the creation or passing of legislation or the addressing of a legal dispute in a court of law, either a state court or a federal court, occurs except within in a particular context and in a particular way. So context counts and deference makes a difference. What do I mean by that? When a legislator or a judge considers any issue involving elementary and secondary, preschool, elementary and secondary education, or higher education, they all consider it from their own personal context as consumers of education, as parents with kids going to school, as people paying tuition bills, as people hiring in the workplace. No education policymaker in the legal realm acts except within the context of being themselves involved in education. They pay attention to the considerations of education reform in the pre-K-12 context as citizens. They pay attention to the controversy over higher education and whether it's accountable and effective, whether it costs too much. Those are things that they pay attention to as citizens. They listen to the debate that's going on currently about the nature of the teaching force and the role of teacher unions in our society and in the workplace. They are aware of those kinds of considerations, and it cannot help but influence their decision making. They also, as individuals in our society, pay attention to the role of family in our society and how it evolves, and they take that into account in many of these disputes. They pay attention to the impact of technology. If you went down the hall and saw the professional development that's going on for the judges right now in the Fifth Circuit in the federal court system, they're doing professional development that is in some respects very much like the professional development we do in education, in the education sector. They pay attention to the use of technology in their profession for good and for ill. They're also well aware of the debates that go on in our society right now about privacy, and in particular what privacy means in the era of big data. So while the legal issues may not smoke out clearly a judge or a legislature's particular personal perspective on the issues we'll talk about today, those factors and the context in which they reach decisions make, I assert, an enormous difference in how they go about their business. It is also the case that there is a very long tradition when it comes to decision making by judges in particular, particularly both state and federal judges. There's a long tradition in education disputes of judges being inclined to defer to the public policymakers, the public education officials whose actions are being challenged. And despite the fear of many educators about being sued, the odds of being sued in our huge industry are actually very small. And the odds of losing a lawsuit brought against you or me for anything we do related to our practice as professional educators, the odds of losing a lawsuit brought against you or one of your programs is extremely low. And this tradition has gone on for decades. Overwhelmingly, the odds are that people suing educational institutions and their officials, education programs, will lose those lawsuits. Now, remember what I said, though, about context counting. In the current context, will that tradition still be true? Or will it change somehow because of changes in the nature of our 21st century context? Ponder that as we proceed, because I think it will become an important factor in influencing the outcomes of some of the legal disputes we'll contemplate as we talk today. One of the things I think that's particularly worth contemplating is that we have in our society right now hugely different perspectives, sometimes held simultaneously, sometimes in great conflict, about what the social and public policy goals for our education system should be. For years, the tradition in our society in the 20th century was that the primary purpose of education was civic. It was to improve the nature of our society, to enhance our economy, to make people better citizens, to promote learning for the sake of learning. In recent years, many scholars, however, have asserted that there is an increasing influence of a tendency to look not at that civic purpose, but instead to look at an increasing interest in the pursuit of education purely for individual benefit. A consumerist approach, a credentialist approach, an approach that some have argued applies in both the pre-K-12 context and the higher education context. Under this perspective, it's a consumer product. And you're there to make sure you get what you need to advance yourself in our society, economically and socially, and you're there to make sure that you get what your kids need to advance themselves. And the assertion is that this is a cultural phenomenon that influences how the broader public thinks about the work we do. Because so many of the legal issues I'm going to talk about today are rooted in controversies about what the public purpose of education should be, what the public policy goals are for all the programs you all are working so hard to implement, I suggest that it's really important to understand that the legal issues, most of them, will be addressed on the basis of making a determination of what your goals were, how clear they were, and how well grounded your theory of action is in approaching those goals. So, what are your goals? Yours. California, Illinois, Delaware, Massachusetts, Florida. What are your public policy goals? And it can't just be something as broad as promoting effectiveness, like the title of your consortium. It needs to be a little more specific than that. And the more carefully you can craft it, I think, the better will be your prospects for contemplating how the legal issues might play out. So take a minute to think, in your state, in your programs, how clear are your program's public policy goals? And then, what is your theory of action for how you're going to meet those goals? And how well do they fit together? Because the goals will frame how courts will look at disputes challenging your programs, and your process for properly addressing those goals could affect the outcome as well, in ways that I'll talk about further in just a minute. So a clear-headed notion of what your goals are, where you're going, and how you're trying to get there are particularly important. And embedded in the paper are a number of checklists that you can use as we work our way through this presentation to help you think about how to further consider the issues that I've presented. These public policy goals, what the government's interest is in pursuing its programs, is a critical part of the inquiry in most of the constitutional issues that might arise under state or federal constitutions for people bringing constitutional challenges potentially about your programs. And the people bringing these challenges could be people who feel that they were not properly treated in seeking a credential, that their higher education program was not properly treated, that they as an individual faculty member or teacher was not properly treated, that a school district wasn't properly treated by the state in the way the program functions. So there are a variety of contexts in which these issues might come up. The first constitutional issue that I highlight in the paper is the consideration of fairness, fair treatment in how government treats individuals and non-governmental institutions. This is a principle that arises under the 14th Amendment's Equal Protection and Due Process Clauses. And this is, in essence, a question about whether government, in running a program such as those that you work with, is treating individuals and institutions in a way that is not arbitrary, that's not capricious, that is rational, and that allows people a chance to feel that they are participating in a fair program. This, in essence, is the type of dispute that was presented to the Federal District Court in Florida, where there was a challenge not to a licensure determination, but to a teacher evaluation system that included value-added measures. The challenge that was presented by the teachers union was, in essence, that's not a fair treatment system because your testing system for K-12 students doesn't provide test scores for every teacher in the state. Yet you're basing an evaluative judgment of every teacher in the state on student test scores. The named plaintiff in the case was a primary grade teacher who was judged on the basis of scores from students down the street at the school down the street because nobody in her building had been tested on the state's testing system for students. The challenge was, that's an unfair treatment in violation of the fairness provisions of the 14th Amendment. The court reached a decision yesterday. I haven't had a chance to read it yet, but my understanding from the little blurb in Edweek is that the judge said that was indeed an extremely unfair system to base a teacher evaluation on the scores of students they never taught who weren't even in their own school. It was so unfair that none of us would want to work under those circumstances. But it was completely constitutional. It was completely constitutional. Now, as I say, I haven't read the decision yet, but it makes me think about the extent to which the judge might have been deferring to the public policy officials, The judge might have been operating out of a context of all the criticism of the teaching force. It's hard to know. But there's an example of how a fairness claim could be thought about in terms of any kind of an educator evaluation system. It's only one decision. It's not probably going to be final. It's probably going to be appealed. But it's one indication of the quest for fairness under our Constitution. Another set of constitutional questions have to do with procedural protections for individuals who feel they're disadvantaged by the system. Do you have built into your system an opportunity for individuals or institutions to pursue procedural protections to ensure that they get a chance to have their point of view heard if they disagree with a decision that's made as a result of the system? What kinds of procedural protections are in place? That's another, the procedural notion of an opportunity to contest government decision-making when you think it was an error is an important protection under the 14th Amendment. The 14th Amendment has also been used, and it's probably the most widely used traditional kind of claim about educational evaluation or testing systems, challenging discrimination on the basis of race, ethnicity, or gender discrimination. These are increasingly difficult cases to win, and there are actually statutes that are more powerful that I'll talk about in more detail in a few minutes, but those claims are still out there and could be potentially mounted. Perhaps more worth detailed consideration in terms of constitutional issues are a new wave of challenges that are being mounted very systematically on behalf of people who have religious or free speech concerns about government programs. And like so many of these constitutional issues or civil rights issues that I'm talking about, there are organized groups of advocates and lawyers who figure out how to bring cases. And the groups of people working on free speech claims and religious freedom claims have been extremely active, including in the education arena. And here the question is, are you pursuing a public policy goal that somehow discriminates against individuals because of their religious point of view, or discriminates against individuals because of the way they express themselves or what they say? You can intrude on people's religious or free expression beliefs if you have a strong enough government reason for doing so. The kinds of disputes that would come up might be people whose religion bars them from being videotaped, either as a teacher or as a student in a classroom being videotaped. People who feel that their religion bars acceptance of homosexuality and who want to express themselves from a religious perspective in a particular way because of that religious belief. These kinds of issues are going to be more and more frequent, and I think these kinds of cases may in fact be the most common kinds of cases that could come up under the United States Constitution in challenge to the kinds of programs that you all are working to implement. Another possibility is a series of questions that come up under the Constitution. This is a less well-defined, less well-litigated set of considerations, but a question about whether the higher education program or the other education preparation provider is under your regulation, because you're approving those programs, affording an adequate opportunity to learn for the future educators who are participating in the program. In other words, is your program approval system properly synchronized with your teacher evaluation system so that students in an approved program are actually getting the kinds of learning opportunities they need to be prepared to succeed in the licensure system? The argument would be under the Constitution, if you aren't providing people a fair opportunity to learn, then you can't penalize them if they didn't learn it. There are also, under state constitutions, some state constitutional obligations to ensure that government systems provide an appropriate opportunity to learn for kids in the pre-K public education system. So you also want to make sure that there is a cohesion among your student testing and curriculum standards, your educator preparation program approval standards, and your educator evaluation standards. These last two are probably not high likelihood legal claims, but I should note that in terms of opportunity to learn issues under state constitution provisions, those cases are the so-called school finance cases. And those are the cases that have been in state courts for years. Texas is probably on its 12th iteration of that litigation under the Texas Constitution. There are attorneys who work almost full-time on trying to figure out whether kids in the state are being well educated under the state school finance system. And when they start looking at the next set of considerations for whether the state system works appropriately in terms of funding and providing PK-12 education, your system will be part of what they will scrutinize if they're aware it's going on. So these constitutional issues are traditional kinds of issues that have been out there for a long period of time. They are still being pursued, and I expect they will continue to be pursued. I think the attention in the cases will shift more from race discrimination kinds of cases to fair treatment sorts of cases, even if those are hard to win. But if I had to bet my money, I'd say the most likely kind of case is a religious freedom case, an intrusion on someone's individual religious beliefs and practices. More worth attention, though, are the federal statutory issues. There are some affiliated statutory issues about protecting PK-12 kids' access to educational opportunity. There are also some analogous state statutes that would apply there. And then there are a set of federal statutory provisions that bar all sorts of forms of discrimination in government programs and educational programs and activities, both public and private. So these are the statutes that bar discrimination on the basis of race, ethnicity, and national origin, on the basis of religion, on the basis of gender and age, and on the basis of disability. I've already alluded to the kinds of problems that may come up in terms of religion-based discrimination. Race, ethnic, and national origin discrimination may be displayed in the statistical reports that you start seeing on candidate performance. The checklist suggests some ways you monitor for that and try to attend to those issues to both ensure fair treatment of these groups, but also to ensure statutory and regulatory compliance. In addition, I think it's worth paying particular attention to the disability discrimination possibilities inherent in these systems. Our society has changed enormously since these federal statutes were first passed. Think about the paddle openings to the doors that we go through daily, the curb cuts that we all benefit from, whether we have a disability or not. What's happening is we've got more and more individuals with disabilities becoming more and more educationally and financially successful, and we're uncovering an incredible number of new ways in which we fail to fully include those individuals in our activities. And the best example I have for the work you're doing is the difficulty of ensuring accessibility to your systems for individuals with disabilities, particularly around the online submission platforms that so many of you are using. I went through an enormous effort a couple of years ago to get all my online course instructional materials fully accessible for individuals with disabilities or people who wanted to listen to Supreme Court cases while they drove to work. God forbid anyone should run into those folks when they're on the highway. And actually, they did well in class. Who knew? But when I turn to my colleagues with significant visual disabilities, they tell me that I only got 2/3 of the way through to promoting full accessibility for my online activities. For a person with a visual impairment, you want to have full access to an online platform like everybody else. If everybody else can see bold print and bullets and skim through a document quickly to find that, they want something that would trigger that kind of easy access in the same way. There is a thought that we've made great progress in online testing, even particularly in the K-12 context, but my visually impaired colleagues tell me that we have not. Stay tuned. The National Federation for the Blind has both brought lawsuits on this topic, but also has legislation pending in the Congress that might actually be one of the few things that will get through Congress in the near future, a bill regulating greater accessibility for individuals with visual disabilities. So stay tuned to watch for that. The other legal issue that I want to bring to your attention is the set of legal issues concerning the quality of the assessment itself. This is the theory of action you're implementing to achieve your big public policy goal. And I know you had some sessions this morning on things like validity and reliability. But the quality of the evidence you have to support your program is critically important in any of the legal issues I just mentioned. And it will also be critically important in the so-called next generation legal issues I'll talk about in a few minutes. Federal and state statutes have requirements about evidence-based approaches. They're embedded in the No Child Left Behind Act. There are provisions in some state statutes about educator evaluation that might actually also apply to educator licensure systems. You'll have to look at your own state statutes to be sure. But there are also professional standards that apply. They're referenced in the NCLB language itself, but they also occur regularly in expert opinion testimony. They occur in the production of testing manuals about programs like your own. And the cornerstones of these requirements are validity and reliability, the defensiveness of the inference that's made about an individual as a result of their performance, the reliability, the accuracy of the score about an individual, the scoring process and the score proficiency choice that you make when you determine what's required to say an individual is successful in a program, and then the security in which your system operates. The protection of the security of student tests, if you include any K-12 student test score information in your system. The security of the submissions that you get so that you can ensure that when candidate Diana submits her application, you know that in fact Diana did all the work, didn't get inappropriate help. And then the way the data about the system are handled as the system proceeds and the evidence in it is processed. So these technical questions about validity and reliability, about scoring determinations, are an essential part of many considerations on constitutional issues, on statutory issues, and they'll be, I think, an increasingly important set of issues in the commercial law-based controversies that I'll be talking about in a few minutes. So every mechanism you have in place to ensure these technical properties in your system are critically important because they could come up in many of the different types of legal disputes. I'll offer a particular word of caution that one of the major concerns about validity issues is a concern about how the VAM evidence will be used if you've got VAM embedded in your system. VAM would be a value added or a student growth measure from a teacher's students or a school's students. And that's an extremely popular initiative right now. It was certainly privileged, if not mandated, by the Race to the Top requirements. There's a lot of enthusiasm among policymakers for VAM approaches. There are a lot of economists and vendors who provide these services. Some of them I know are your sponsors. I'll try to be nice. The difficulty is that while there are a lot of economists who support these systems, there are a lot of psychometricians who developed or are expert in the underlying student assessment systems who've raised grave questions about the use of VAM. So one of the things that will have to be watched closely as legal issues unfold is the extent to which judges, if they're asked to make determinations look closely at VAM and raise the same kinds of questions the psychometricians have been raising. Stay tuned, we'll see, but please be alert to the fact that that's one of the embedded validity disputes in the potential legal controversies that I see coming down the road. So as you look at your system in your state, what do you see about the evidence you have about your program? How much is there? How strong is it? How systematically are you collecting it? Are you regularly acquiring it and reviewing it? And how strong is that evidence? How persuasive is it? Now, the judge in Florida who decided the case yesterday probably didn't delve into that very much, but he delved into it far enough to know something about the quality of the evidence about that system. Other judges might look at it quite differently. So these are traditional kinds of considerations, traditional kinds of technical issues that come up in the kinds of work you do. And an evolving context in which they occur. When they first asked me to write this paper some time ago, I probably would have ended my paper there. But as time proceeds and things unfold, a new set of things come up that I call next generation issues. These are the issues that I think will be the legal issues with the greatest momentum in the next few decades. New sorts of issues that have been dealt with to some extent in our system of education laws, but not thoroughly enough to address the present context. So the first one I'll talk about is privacy. We have a certain cultural tradition about privacy in our society that is intended to respect an individual person, their professional reputation, their individual space. We've protected that as a matter of common law. Judges and juries make regulations about intrusions on privacy regularly. And if someone inappropriately intrudes on another's privacy, so one issue that you're involved in here is an impact on people's professional reputational interests and a potential intrusion on their privacy if you erroneously say something about them that harms their professional reputational interest. That's the sort of lawsuit that has gone on for centuries that can result in monetary damages against the person who articulated the erroneous thing that invaded privacy. That can happen. I don't see a lot of it possibly happening here. But here the privacy issues, I think, will have a lot of possibilities. Every state has a statute about recording conversation. They're often called wiretapping statutes. I never thought I'd be talking about wiretapping in the field of education law. I thought that was something more for criminal law shows, but in many states, wiretapping is the broad term used to reference any kind of surreptitious recording or any recording without consent. The general point here is that state laws have provisions in most states about instances in which you expect privacy and that privacy should be protected. If it's a public place like this, we probably have no expectation of privacy because we now are pretty sure there are cameras everywhere, there are people listening everywhere, and in a lot of school buildings there's a great deal of space that's not private at all because the kids know that there's a camera in the hallway and there's a camera in the gym and auditorium, et cetera. But there are places where we're clear there should be privacy, a private conversation between a teacher and a student, one-on-one. That would be protected under these statutes. A conversation in a classroom, not so clear, maybe protected, maybe not. The principle of the state privacy laws is that if the state privacy law recognizes the privacy of a certain kind of communication interaction, you need to have consent before you use a recording of that information in a context like a portfolio submission. And you need to clarify whether the consent needs to come from a student or the parent, and at what age the consent giver changes as a student gets older. If you don't have consent, you shouldn't use a recorded material in a portfolio. And there are some good guidance out on how to get consent, but there's also a lot of panicked ignoring of the guidance because I got to get my portfolio in and that mother never got back to me. You need to think hard about what your state privacy law requirements are and how to accommodate the practical problems that come up in your system. Most of us are probably aware of the primary federal statute governing privacy, the Family Educational Rights and Privacy Act, or FERPA, which governs student records and also operates under an assumption that there's certain kind of information that requires particular careful treatment by educators, other information that can't be disclosed without prior consent. The unfortunate circumstance we're in now is that FERPA is an antique statute when it comes to current information acquisition and exchange. The Obama administration has made a number of regulatory changes in how it interprets FERPA, but many people are unhappy with those changes, and many others are saying that Congress just needs to go back to the drawing board to come up with new FERPA language to address the contemporary context. The primary difficulty I see for you in FERPA is the problem of consent for disclosure of recorded information, either about the higher ed student or the K-12 student they work with. That's probably manageable. What's with a good consent form and adherence to it. The more complicated issue is the fact that the Obama administration broadened the notion of what is allowed when you use a private vendor to provide services to an educational institution, or you hire a vendor to maintain your data. These big data questions, the Obama administration dealt with by saying, in essence, if you hire a vendor to take your student private information and manage it for you, that vendor's like you. They're like the school. They could handle and exchange information the way two teachers would. A surprisingly swift negative reaction was mounted by privacy advocates and by parent groups, with a great deal of hostility toward the vendors who were collecting and maintaining that information, and a great deal of suspicion about whether those vendors were in fact acting appropriately. One of the vendors was in Bloom, was subject to challenge in a New York State court case. Eventually, the state legislature amended the New York statute, and in Bloom recently announced that it's going out of business. Nobody knows what the full range of privacy issues will be when it comes to big data, the use of outside vendors, the ways in which the big data companies who have the information could use the information, whether people would regard it as appropriate educational use or not. So there's a new frontier of questions that have come up about how you really handle a contemporary context in which there's a lot of privatization of what was previously public government educational institution activity. People both love technology and they're suspicious of technology. And the suspicion of technology skyrocketed after the Snowden episodes, or after the Target data breach, when they found out that Christmas shopping had been intruded upon because of a data breach. So there's a lot of ambivalence in our society about this right now. But the bottom line is you're engaged in an activity where you potentially have outside vendors dealing with information in an uncertain legal context, where the Obama administration has said, in essence, it wants to protect those kinds of transactions, but where parents and students are raising questions about the latitude that outside vendors should be given to manage big data sets about individual students. Some of those vendors are people like Pearson, who have data about this system, right? And who do lots of other kinds of lines of business about schools. What are the boundaries about what they can do and they shouldn't do to appropriately protect the privacy of every nugget of data they were given and every piece of metadata they could generate? I wish I could give you answers here, but we don't have them. It's too much of a new frontier, and the law is too unclear. But the swift activity with which parents organized themselves in New York and with which the In Bloom operation was brought down, the court case filed in these kinds of disputes generally last about 35 seconds, but the ramifications that come after can be enormous. So one set of new generation legal issues will be these sets of questions about the new context, the new approaches, and then what the law should do or where the law should go in light of questions about data and privacy. That's one set of juicy issues I see for the future. The data warehouse problem will need to be resolved relatively quickly. The other issue that relates to privacy that will have to be resolved relatively quickly is a big conflict between individual privacy and the public's right to know what's going on in government. And here the best examples are the circumstances in which the local media in Los Angeles or New York decide they either want to post teacher performance scores or have somebody calculate teacher performance scores so that they can put them in the press or put them on their websites. And the clear tension is between laws that promote transparency in government operations and laws that protect individuals' privacy over their performance. And in the 3 disputes that have come to light so far in the state courts that I know of, all 3 judges said it's more important to give public access to information than it is to protect an individual like you or me about our performance as educators. There's a public policy choice that was made there. I'm not saying that's how it would always be made, but I'm saying it's an issue worth further consideration on our part. The other set of next generation legal issues comes purely from the business context. Not stuff I ever thought about when I was going to law school other than I have to know a little bit of this to pass the bar exam. Not stuff I thought I'd be talking about as somebody who specializes in education law, but I think some of the most provocative legal issues that are going to come up in the near future about the kind of work you do are issues that are brought from a purely commercial perspective. And I think they're driven by that idea that education isn't so much for civic benefit, but for personal individual good. And here the idea is that if the educational system doesn't function the way I want it to benefit me, I'm going to regard it as a bad business deal. So I might argue that I have intellectual property that should be protected because I'm a teacher and I created it and I should be able to do with it what I want. And if you don't give me full latitude to own the class lessons, the lesson plans that I pulled together, I have a complaint against you. This issue of intellectual property is particularly difficult because in the past, the commercial approach to this problem was to say when teachers create classroom materials, they're doing work for hire, so they're not working on their own. They don't own the copyright unless it's bargained away in a collective bargaining agreement and treated differently because of the collective bargaining agreement or because somebody gets a state statute to be written differently. Oh, and none of that answers the question if class work of a teacher is work for hire because they're employees of educational institutions. How do we treat student teachers? They're not employees, or maybe they are employees if they're doing their practice teaching as part of an internship or a residency program. So here's another thorny wicket that nobody's quite sorted their way through. And it will have to be resolved to the extent teachers see what they produce in classrooms as being a valuable product. Now, sometimes they just want to give it away, but sometimes they want to sell it. And I was surprised when one of my students went out to go look how much there's available on the internet for teachers who want lesson plans from other teachers or class activities, et cetera. So here's a business thorny mess we have to sort out. More difficult, I think, is this other version, and probably more passionate version of bad business deals. If I'm harmed in a licensure decision, the argument goes, I've gotten a bad product. And in fact, there was a very quick settlement against the Educational Testing Service a couple years back for a scoring error that harmed several thousand candidates who took the praxis. It was settled so quickly out of court that you barely would have noticed it was there. But it was an $11 million settlement on behalf of the people who'd been subject to the scoring error. And it also resulted in considerable attorney's fees for the attorneys who brought the case, who do those cases on a contingency. And the attorneys who brought those cases are not the kinds of attorneys who hang out with you folks at these kinds of settings. These are attorneys who work on toxic tort litigation, the BP oil spill, lemon cars. From that perspective, a bad test or a misscored test is just another bad product. And the way you deal with that is to use a business lawyer to challenge it. Now, the way you prove it's not a bad product is by looking back at that body of evidence you have about the quality of the program you're running. If you have it, right? It's another reason to have it. And this is another thing I never thought I'd have to learn about, whistleblower cases. So I'm doing a big evaluation of the Washington, D.C. public schools, and one of the issues that came up was an allegation that teacher evaluation system that Michelle Rhee had put in place led to a bunch of fraudulent behavior on the part of many educators subject to the system. That was a high-stakes system, big bonuses, loss of job, et cetera. The claim that was used was because federal money led to the operation of that program, fraud in the implementation of that program disadvantages every taxpayer and citizen in the country. There's a federal statute, and there are many state statutes that provide whistleblower opportunities for people who report fraud in government operations. So an individual who'd been brought to be a principal in one of the Washington schools from out of the district saw some things that she thought were inappropriate, filed a whistleblower claim. It was not a successful claim, but whistleblower claims, when they do succeed, can result in millions and millions of dollars of financial reward to the citizen who blew the whistle. It can come from anybody from within the system. And these are so prevalent in Washington, D.C., because there's so much federal government activity there, that there are, I understand, boutique law firms that specialize in representing people in whistleblower claims. So if you think about education as being a consumer product, and you think about someone who doesn't like the way the product is functioning, here's a new set of legal claims that may come up. Sadly, on a similar note, another set of legal claims are criminal law charges. And there are, I believe, still serving in one Texas prison, a superintendent of schools who was convicted of criminal charges for leading a student cheating initiative on the student tests in his school district. There are a number of educators in Atlanta, Georgia, who are facing criminal charges for similar kinds of claims. Some people have plea bargained out. The superintendent of schools, the former superintendent of schools, is one of the individuals who is facing criminal trial, although she's gravely ill, so I don't know whether the trial will happen. But this is an instance of people feeling that the system isn't functioning properly and undertaking investigation to try to understand why and what to do about it. There was a similar investigation in Washington, D.C. In Washington, D.C., it was an inspector general investigation. It's kind of a limp investigation, was sort of a limp finding. In Atlanta, the governor turned the investigation over to experienced criminal prosecutors and former detectives. They used criminal investigation techniques, like you would see on a cop show. They wired teachers and turned them against each other and got wiretap evidence with subpoenas of people talking about cheating in the system. These are not the sorts of things that I ever thought we'd be dealing with as people who care deeply about the profession of education. But as the stakes go up, we know people get more and more worried about the consequences. And as education becomes more and more a consumer product, there are more and more possibilities for these kinds of variations. So it's an interesting time to be working in the field. I don't want you to be more nervous than you were when we started. I want you to think hard about what you're doing and how you're doing it so that you can make sure that your practice is situated in a consideration of the ways in which people on the outside or from within will look at what you're trying to do and make judgments about it, not necessarily court judgments, but any kinds of judgments. So having a consortium like the one you're in is vitally important because it gives you a chance to exchange information about how to pursue best practice. It's also vitally important to do things like, I would hope, go through the checklists I offered you in the paper. So for each of the legal issues, I've offered you checklists about how to think about your work, how to go about your business. Unfortunately, a bunch of the checklists include see your lawyer. But that's in part because of the fact that there are so many state variations on these themes that it's hard for someone like myself, even though I'm licensed in multiple places, it's hard for me to know the law in all those different places. But I hope that the paper and the checklist give you an opportunity to clarify your goals, your theories of action, your processes and practices. I hope I've given you a little sensitivity in this presentation to the sort of rapidly evolving context in which you're working. I think the notion of deference in support of education reform will always be there, but it won't always say yes to everything you do, particularly if you don't do it thoughtfully and carefully. So thank you very much for coming, for your time. So thank you. And questions or comments?
Hi. How is the data warehousing issue any different from medical data warehousing?
Ooh, great question. So it is in some respects no different, although I will say I don't know enough about how any of those operate. And there also have been plenty of concerns about data warehouses about healthcare. There is another statute that applies there, HIPAA, which some have argued also will apply in the school context if you have health-related information about a kid. There's another set of legal protections. But there are very similar issues, and from a contextual perspective, the healthcare issues, the healthcare reform controversy, all these things become cultural phenomena that influence how people think about government systems. That may be as important as the fine details about the law or the process.
I was wondering if you could give a little bit more comment on the validity of assessments or evidence needed to demonstrate that as we add assessments into either licensure or program approval where there might have been none, and also about perhaps the weighted context of that given the general cultural conversation around assessments overall.
So the validity questions are extremely complicated and difficult, as your question suggests. And part of the challenge of a validity consideration in this context is that you really need to have a kind of an evidence-driven notion of the broad scenario of validity-related questions. So to the extent that you're collecting data, for example, about teacher effectiveness or educator effectiveness in many different contexts, that data could be used to challenge the validity of any particular assessment component in the system. So for example, if the portfolio assessment of a future educator is rated by trained raters through a system like the EdTPA system attempts to create, where there's been an effort to create a scientific foundation for the approach, and it results in a score of X, you have a lot of other data about that candidate, right? You have how they did in their classes in higher ed, you have evaluations of how they perform in the practicum setting, all of these sources of data which may converge or may conflict. And you need to design a validity research agenda that takes into account all the potential sources of evidence that should be considered either in your validity pursuit itself for the portfolio assessment, or that might be used against you if somebody doesn't like your portfolio outcome. So it's like a student of mine who's doing a doctoral dissertation who wants to go off and study something. Say it's the only time in your career as an educator you can limit the study so small that you can control what you have to consider. This is the opposite of that. It's a broad set of considerations, and it calls for technical expertise as you think about the validity consideration. And it requires the expertise potentially of people who might take very different disciplinary approaches. So you may need a traditional psychometrician. You may want somebody who does econometrics. You may want someone who can look at the program evaluation system embedded in your program approval system and see how that fits.